Okay, we're recording. So let's share my screen. Like that. Then I have to minimize your faces and hit play. So stop me if you can't hear me or there's some kind of glitch, but otherwise I'm just going to plow forward here and get through our slides. So to recap, last week, this is taken directly out of the law that talks about the duties and obligations of people in your profession. And this really covers a good amount of what we talked about last week. And 2A is really what I want you to commit to memory. You've done this. I'm sure you're familiar with most people say PARQ. I just say PARC because it's easier. But when you're talking about informed consent, you have to do this. You explain the procedure, the alternatives, the risks, the questions. That's what you have to go through. Where you can find this document, and I've linked it in the course. So if you go to Canvas and you go to course information, I've linked it here. And when you click on this, this will take you to the Oregon Board of Chiropractic Examiners, Regulations for Chiropractors and Chiropractic Assistants. This is a long document. You need to, this is something you should have printed or on your, I print things because that's just who I am. But you should have this saved somewhere if you don't already. And oh, wow. And this will go over everything I'm going to cover in this class will be within the guidelines in here, but I also try to have to expand a little bit because not all of you will be staying in Oregon. So find this link, save it, print it, do what you need to do to have it. A lot of what I'm going to do is going to come from Division 35, Code of Ethics, which is where I found that previous bit on this slide. So I'll be highlighting this as a recap from every week, but be familiar with that document. And when it comes time to take like your law and ethics exam, to get licensed, that will be your study guide. And so we talked about justice, and here's a nice quote I like, is that justice is the sum of all moral duty. Remember, justice just means to be fair. And now remember, equality is not fair, equity is fair. If I'm 6 foot tall and my wife is 5 foot tall, if we're trying to look over a fence and we're each given a 3-foot box to stand on, well, that's equal. However, it does not put my wife on the level of being able to see over the fence at that time. So an equitable thing would be to, or a just thing would be to give her a 5-foot box and me a 2-foot box, or what, you know, however the math works out. I'm a lawyer. I'm going to do all that math stuff. But you need to understand that justice isn't equality, it's equity. And equity is part of the founding principles of the healthcare profession. And so let's just do Law 101 this week, just to understand now I'm covering, of course, US law, because that's what I happen to know. Now, fortunately, US law is based on the Western model. So stemming from really the English common law, looking all the way back to the Magna Carta in the 1200s. But Canada is very similar. The UK is very similar. South Africa is very similar, except for that they don't really use juries, which I think has a lot of advantages. But in general, it's essentially very similar. But my Canadian students, I've linked a lot of resources throughout this course that you need to look into, and just to understand the basics of the legal system. And I'm giving this to you so you understand. When you're dealing with all these concepts where we're talking about like negligence and malpractice and boundary violations, people get confused about what kind of court is going to handle your problem. And so to start off with, law comes from 2 sources. There's statutory law. You hear the word statutory, think statute or law, and that's law that's passed by a legislative body or by the voters by a referendum. So those are laws that are written. And so you vote for a state representative or a member of Congress or a member of the Senate, and they go off and they go and pretend to do work, and then they pass laws that are mostly inconsequential or stupid. And then those laws go out into effect. And then those laws are tested. And when they're tested in a court of law, which is another branch of the government. And the court of laws deal, the whole purpose is to, one, prosecute according to the law, and two, interpret the law. And so courts can make changes to the law. Not every court. Trial courts can't change the law. The trial courts, when you go in front of a jury or at a bench trial in front of a judge, their responsibility is to adhere to the law as written. But that isn't the end all with those things. There are different layers to this. And so the common law comes from those extra layers where cases from trials are appealed, and the appellate courts are tasked with interpreting the law as it should apply, and they can make changes. And so these laws can get struck down. This is not unfamiliar to most people. In the recent years, we've seen things like Roe v. Wade being overturned. And so you've seen that the courts can go in and argue with each other about the meaning of a law, and then either strike down certain laws or uphold them. Another thing that's in the news a lot is like when states gerrymander voting districts, and then they get sued over it. And the courts have recently really cracked down on that, saying, hey, you're being idiots about this. We're going to remove what you've done, and we're going to order you to redraw it in a fair manner. So courts have an insane amount of power. So here's an example. So, and this really happened. So in an effort to boost their economy, a town in New Jersey had an ordinance passed by the state legislature that says that all contractors who are awarded government contracts to build, I don't know, I put Vermont in there, but I think maybe just as an illustration, but in the real case, to only hire people who resided in New Jersey. But in the same sense, they could have passed a law saying we'll only hire people that come from Texas. And so they can pass a law that says that. But residents of Philadelphia, just across the river there, were upset about losing out on these jobs. And so they sued New Jersey over it. And the courts, as they reviewed the U.S. Constitution, they agreed with the Philadelphians. And they struck down the New Jersey law by reasoning that an employer cannot discriminate against someone based on the residency of the person applying. And so that statutory law was struck down and now has been replaced with common law, which just says, hey, you can't pass laws that discriminate based on where someone's from. So in the hierarchy of things, this is kind of how it breaks down in most Western nations, but especially in the United States. So the end-all be-all is the U.S. Constitution, a very brief, short document that confuses the heck out of everyone. But has laid the foundation of who's in charge around here. And so from there, it's created the three branches of government we have. We have our legislative branch, which is Congress. We have our executive branches, which is either the presidency or the state's governors. And then we have the judicial branch, or the courts. And then each of those have their own agencies below them. So when a president or a governor signs an executive order, what that means is that president's not making a law. What they're doing is they're sending an order to their agencies saying, this is how you are going to operate business. So a big and a popular one, back when President Obama was the president of the United States, he sent an executive order to the federal law enforcement agencies. So like the DEA, the FBI, the CIA, the ATF. And they said, and that executive order said, we will not prosecute or seek to prosecute crimes related to cannabis consumption. And so no federal officer was going to raid a weed dispensary because federally it's still illegal. I see a couple chats. Let's see. Pretend to work. There we go. Oh, now I can't see it, so I have to exit out. There we go. And so the states are set up the same way. Each state has their own constitution, and then they have their state courts, their legislature, and their state executive. Ooh. Is that the right? So the U.S. government was set up on what's called a federalist system. That means two masters. So in a federal system, there's two people in charge. And in this case, it's the federal government and the state territory government. Now, the Constitution was pretty explicit about who's actually in charge. And so even though the federalism has the two bosses, Article 6, paragraph 2 of the Constitution establishes what's called the Supremacy Clause, that constitutional law from the federal government takes precedence over state laws and constitutions. It prohibits states from interfering with federal government's exercises of its constitutional powers and from assuming any functions that are exclusively entrusted to the federal government. It does not, however, allow the federal government to review or veto state laws before they take effect. Stat laws, I got to fix that. And so just because a state is talking about, let's say, banning middle-aged white men from owning property, like me, let's say they're thinking about that and they're really going to think about passing a law, the federal government can't proactively come in and say, no, you can't do that. They have to allow the law to take effect before coming and suing them over that. And so as much as that might be a good thing in some cases to do, it's just prohibited. So the legal systems are divided into three specific areas. They often can relate and do relate to each other, but in general, it's the criminal courts, the civil courts, and the administrative courts. And all three have the ability to impact your liberty, which means your right to choose, your finances, and your behavior. Administrative courts, we won't talk about too much until we talk about insurance law. But if you deal with workers' compensation, that goes through administrative courts, which is very, very differently run. The criminal justice system, I put that in quotes because you can tell my feelings about it, deals with the violations of laws and carry the potential for incarceration, which means going to jail or prison, fines, and in some U.S. states, it can lead to your death. The U.S. system allows the government to put you to death for certain offenses. And we don't have a good track record of actually making sure someone was fully guilty of those things before doing that. The civil justice system deals with violations of laws which are not considered criminal per se, but even though it can, and includes disputes between individuals, groups, or companies. These courts cannot put someone in jail, but they can give fines, they can award judgments, and so they can give someone like money or property, and they can restrict direct behavior or choices through things like injunctions. And so you see these things, and the civil courts include things like family courts. And so they can choose how often you see your kids. They can choose how much money you'll have to pay in support of those children. And they can choose all sorts of stuff. The intersection between the civil and the criminal courts is frequent because in a lot of cases, if someone commits a crime, they can also be sued in civil court for that crime. Think of O.J. Simpson. He won his criminal trial. But he lost the civil trial. The civil trial found that he was liable for the deaths of Nicole Brown Simpson and Ron Goldman. Now, we'll talk about specifically why that might happen in a minute here, but there's a different burden of proof. And then in the administrative courts, it's kind of a quasi-court. It hybridizes the other two and deals with the administration of particular rules outside the scope of those two, like workers' compensation. So the court structures are this way. We'll start at the bottom. You have your municipal courts, your traffic courts, your small claims courts, where if you get a ticket, you go in, or if you got to sue someone over not paying you for mowing their lawn, you start with those municipal courts. A lot of the cases, like especially in my rural part of the country here, some of these municipal court judges don't even have college degrees. They're just appointed, and so it's really the Wild West out there. But in general, the courts you're going to deal with a lot are the trial courts. And so you have your trial courts that are on your state level. So you're either circuit or district courts for your state. In Utah, we call them district courts. In Oregon, they're called circuit courts. But there's also federal courts on that same level. And there's certain rules whether something can be taken to federal court, and usually has to deal with something valued over $70,000 or more, $75,000 or more, actually. And so I do a lot of federal practice, but it's for way more than that. So I never really have to worry about that low number. And trial courts are tasked with applying the law as written. Then you can appeal. So if you lose at the trial level, it's not over. You can appeal the decision if you've done proper things during the trial, like objected and preserved the objections. And so you go to the appeals court, which is the same deal. There's a state and there's a federal. It just depends on what courts there's in. And you can petition to move one from one to another court. It just depends on the circumstances and if they apply. And the appeals courts are not jury bound. They're usually a panel of 3 to 5 justices, usually just 3 of these judges who are appointed usually by the governor. Sometimes they're elected, and they are tasked with interpreting the law according to the Constitution of either the state or the United States. And so they are a very dangerous court to be in, because if you're going to appeal something, you have to weigh the risk that if you lose, you may end up changing the law for everyone in your position going forward. And so I've been in situations where I've represented big companies, and we ended up winning these cases. And the other side represented plaintiffs who were allegedly, they weren't actually, but injured by my clients. And they wanted to appeal, but the judge warned them wisely and correctly that, hey, I'm telling you right now, the law is pretty solid on this, and the courts are going to handle it in a certain way. And if you appeal this, you're going to ruin, hey, lawyers who make their business on these type of lawsuits, you're going to make it really hard for you to do this anymore going forward. Because in that trial, my clients were completely not at fault for these injuries. However, we'd still made offers to make this go away, because it's just more financially feasible to do that sometimes. And so these lawyers often get their clients to take these offers, and they can make their money and move on to their country club. And so it's a skeezy system, but there's a lot of plaintiffs' attorneys, usually the ones that have commercials on TV, are like that, because they got to pay for those commercials. And so you got to weigh that decision going forward, whether you want to ruin this for everyone else if you don't have an absolutely good position. And even if the appeals court makes a certain decision, you still have the option of trying to appeal it to the higher courts, which are the Supreme Courts. If it's a state issue, you can go to the state Supreme Court. If it's a federal issue, you can go to the U.S. Supreme Court. And even if the state Supreme Court rules, the U.S. Supreme Court can still rule against them. So the state Supreme Courts aren't the end-all be-all, but you don't have a right to actually have your case heard in front of them. They get to pick and choose. The U.S. Supreme Court takes about 70 cases a year. So most people get theirs. No, we're not going to review yours. The case is settled. And essentially, by rejecting to hear a case, they're ruling on the case, saying, no, this is settled. We're not even going to take our time with this, which is kind of a ruling on its own, isn't it? And so the criminal courts. So what's the purpose of our criminal courts? There's no really solid answer for why we punish crime. So the 2 basic philosophies under the legal system is, first, recidivism, which just states that people deserve to be punished simply because they committed the act. So it's mathematical. If you've done X, it must equal Y. And so we see that with things like mandatory sentences, saying, hey, if you get 3 felonies in our state, you get life in prison, period. And so places like Idaho have that, places like Texas definitely have that. And so there's these recidivistic things that say, listen, we just want to punish you simply because morality dictates we must, which is a dangerous road, because if you start talking religious philosophy with law, you're going to have tyranny in every case, no matter what your religion is. No religion should rule any country, because it's just garbage to do that. And so, it just doesn't work. And so the second theory is utilitarianism. And I always cheese off some hyper-religious people. I'm sorry about that. I'm not sorry about that. That's just the way I think, under ethics, we should view things, is that forcing your religious views on others is unethical. And that's going to apply to your practice in a lot of cases. When I teach this course to people who deal with things like blood transfusions, there are certain denominations of Christianity that are against blood transfusions. And as much as you want to hammer down their throats how wrong they are about that on the healthcare side, they still have autonomy, and you have to respect their autonomy on that. And so it's a real sticky position to be in, but your ethics dictate that you can't force that on someone else. So if you're a member of one of those faiths and your patient needs a blood transfusion, you have to do it. Your religion is irrelevant to your practice, because you have agreed to practice under the rules and the ethics of that profession. And so if doing something in your field is against your religion, you need to leave the field. And so lawyers need to learn that lesson more than anyone, I think, because we're probably the biggest butt bags about that. And then utilitarianism, and this is, I think, a little bit more widely understood, and this is how a lot of people, parent their children, is that criminal behavior should be punished as a deterrent for other people. And so, if we chop off the hands of thieves, if I see someone walking around without hands, it's going to deter me from wanting to steal. So, I mean, there is some merit to that, I guess, but is that moral? Is that ethical? There's a lot of debate with that. And so those are the two kind of foundational philosophies under which why we justify our punishments of crime. So if you go to the top of it, capital punishment, do we kill people who murder because they deserve to die? Or do we kill people who murder because it's going to deter other people from murdering? And you can make arguments one way or the other for both of those. Well, that people do make arguments. That's just why we have differences in opinions between the states. And so, but do either work on their own? Not really, because we still have crime, right? If any of them worked, we wouldn't have crime. And so clearly the root of crime is due to something else. So just so you understand the basic terminology, the parties in a criminal suit, you have your defendant, the person alleged of a crime, and the person bringing it is known as the prosecutor. And so you'll see them as listed as the people or the state or the United States government. If you're in England, it'll be, like Her Majesty, Regina versus, or I guess it's Reggie now that we have a guy king, a dude king. And so it's usually, they say the people versus, the people versus O.J. Simpson. The people means the prosecutor who represents the people of the state of California in that case. The remedies we talked about are there: the jail, prison, probation, house arrest, halfway houses, treatment, fines, protective orders, or death. The burden of proof in those cases. So if you're going to be charged with a crime, you need to know this. It's beyond a reasonable doubt. That's a ridiculously high burden of proof because you can paint reasonable doubt among a lot of stuff. So arresting officers really have to know their crap if they want to make charges stick. In these courts, the Constitution guarantees you the right to counsel. So if you can demonstrate to the court that you can't afford a lawyer, one will be appointed for you. I know some wonderful public defenders, truly, but they're free, and in most cases in life, you get what you pay for. Public defenders would be fantastic lawyers if they had a reasonable caseload, but they're carrying 3, 4, 5 times more than they can. And that's just the way the system works because we don't pay enough money to have enough public defenders to make it worth it. So understand that if you're charged with a crime, here's your basic terms, but the person's going to have to prove beyond a reasonable doubt. But don't let that persuade you to commit a crime cleverly, because even the allegation of a crime will destroy a doctor's career. You see this most plainly in like Hollywood, even or in professional sports. Just the accusation alone is enough to ruin you. So if a doctor is accused of sexual advances, inappropriate sexual advances or boundary violations, and that's put in the paper, even if it's not true, you will take a significant hit to the degree that your career is over. So you have to be that careful about stuff. Truly, documentation is important. Boundaries are important, and avoiding those DMs and social media is really important. Just because things can be twisted, you have to think like a lawyer in every instance, especially when you're not practicing at the moment. When you don't have that lab coat on, you still have to think like a lawyer, trying to protect your job, because allegations are enough in the court of public opinion. Civil courts, usually those are called torts. Those are lawsuits where something called damages have been alleged or incurred. And so the parties in that so the defendant's still called the defendant, but you need to know the difference in that is that in a civil lawsuit, the person bringing the action is called a plaintiff, like a complaintiff. Someone's complaining, going to the court saying, hey, this is what's happened to me. This is who did it. Now this is what I want. That's essentially the basis of a lawsuit. And they're represented by civil litigation attorneys or themselves, which is called pro se. Don't go pro se into court. Please don't do that. It makes my month when I have a pro se person against me, because it's just easy. It's just easy to do. And so don't represent yourself, and don't let AI or Rocket Lawyer represent you either. Pony up the cash. You're gonna appreciate it in the long run. And so when you're in the civil courts, There's things that are available to you like that those damages that could be money or the return of property or the exchange of property. It could be injunctive, which means behavior, so getting a restraining order, stopping someone from doing something in general. But most common in these civil cases is a term that you need to be very familiar with and boldly write in your notes is negligence. Negligence, negligence, negligence. We will cover negligence probably weekly. It's going to be involved. And it's misunderstood and also very simple at the same time. So this is what you need to know in your notes about negligence. This will 100% be on the midterm. 100% this slide will be reproduced word for word in questions on the midterm. Take your screenshots now. And so in order to justify or show negligence in court, so if you're being sued or you're wanting to sue someone under negligence, you need to first prove duty, then breach, and damages and causation. So duty means a duty of care. So that duty of care is highly dependent on what's going on. It depends on the person at the moment and what is expected of them under a reasonable standard. And so a reasonable person driving a car knows to stop at a stop sign. You have a legal obligation to stop at a stop sign. You can breach, for that second term or factor, you can breach that duty by running the stop sign. So you have a duty, stop at the stop sign. You have a breach, you didn't do it. Damages, well, you hit someone. You either hit another car or you hit a pedestrian. And so you've caused damage to someone in some way. And then that last one is causation, that your breach of your duty is what caused the damages. And so you need to show, if you're trying to prove it, you have to show that your damages were a result of the duty and breach that you were alleging. That seems pretty intuitive, but in a lot of cases, that causation is pretty hard, especially in medical malpractice cases or medical negligence cases. Those are two different things, by the way. And so if you're trying to prove that, or someone's trying to prove that you were negligent, if they're saying that, let's say you were performing an adjustment and you cracked a vertebra, well, if they have to prove that they didn't already have a cracked vertebra, right? And so you're going to do discovery during your case and find their prior. If you sue someone, your right to privacy is gone. And so if someone came and sued one of my clients and saying, I have emotional distress, I get to access that person's mental health records and I get to read their chart notes from their doctors. That's not safe anymore. It's completely exposed. And if I find it relevant, I can pull it out in front of the court for everyone to see. And so weigh it heavily if you're going to sue someone for specific things, because a lot of people will sue for things like loss of consortium, which is like if I got hit by a train and my wife I sue the train company for hitting me. And they say, and then my wife says, well, I want to sue for loss of consortium, which means she lost my companionship. And in most cases, consortium also means things like my physical intimacy. Well, then they get to depose me and my wife and ask us questions about our physical intimacy. Things like your journals or your diaries are not private. They will come in every single time and you have to turn them over. And so they can look at our texts between each other and see if we were being saucy. And it's, for people, it's crazy embarrassing when I ask people, okay, well, how often would you engage in intercourse with your spouse prior to this? And I get them both, independently to answer the questions at different depositions or in court. And they go, okay, well, for how long? How long did each session last? What positions did you use? And ask very, very personal, crazy questions. And so you have to be careful what you allege, because you have to prove that causation part. And so that there weren't issues already happening. Happens a lot in car crash cases. You'll see this with your chart notes as you treat patients who were in car accidents, is that causation is going to be huge. And so lawyers will wine and dine you. I used to have an expense account when I was a plaintiff's attorney where I would take chiropractors, specifically golfing. I'd take you crabbing or deep sea fishing. I took one pheasant hunting because that was his deal. And they will wine and dine you to get you to refer to their patients. And then they will tell you important things to put in your chart notes, like causation. It is my opinion that Mr. So-and-so's neck injuries are 100% due or 50% due or whatever amount due to this accident. They want those affirmative statements of fault. But this is where we're going to focus on for the rest of our time here. It boils down to the concept of reasonableness. So ask yourself, is this something a reasonable person in this particular instance would do? And so we'll cover that, let's see, in one more slide. And so a lawsuit is composed of, and these will be important for you to understand, and there will be questions on this on the midterm. So, look at this page closely as well, take a screenshot. I'll also post my slides, of course, or they already are. So there's the complaint, which is the actual lawsuit that's filed with the court. So if you're a plaintiff and you write a lawsuit, that document is called a complaint. It's often preceded by a demand letter, which is not a court document. I send demand letters every week. Then if you are served with a complaint, if you're being sued, or if someone's if you're suing someone, the other person or you get to file an answer to that complaint. You have to. If you don't file an answer, you automatically lose. It doesn't matter if the claims are frivolous at all. People are allowed to sue you. And so that's a big piece of advice I want to give you all. Don't ever waste your time asking the question, can I be sued? The answer is always yes. You can always be sued because people can make things up. They can file frivolous lawsuits. And if you don't answer that lawsuit, you will automatically lose, and they will get everything they're asking for in that complaint for the most part. So yeah, you have to answer it, and you have to spend the time and the money doing that. It costs hundreds and hundreds of dollars to file a complaint and to file an answer. Within the lawsuit, then you start filing motions. Either party can do that. You can file a motion to dismiss. You can file motions for discovery, to enforce discovery. There are things called interrogatories. They don't have them in Oregon, but they do have them in most other states, where they ask you in a court document specific questions, and you have to answer those questions, yes or no. Discovery is when both parties get to ask each other to pony up their evidence. If it's requested, unless it's protected or privileged, you have to disclose it. Depositions are very common in lawsuits, where everyone that's a party to the lawsuit gets the opportunity to ask each other, with counsel present under oath, questions, and they are held to those questions. And so I ask people specific things in depositions that I'm going to ask again later at trial, to make them, because at trial sometimes I get them to testify to something slightly different. Then I bring up their deposition testimony in front of the jury and saying, wait, this is different. Are you just making this up as you go along? And so a good lawyer knows how to ask deposition questions correctly. And then trials, and we talked about what a trial is, but it's in front of a jury of your quote unquote peers, and it takes place, so it can be one day, rarely is it one day, to up to several weeks. I've had a trial that's lasted 2 months. Very financially good month, or good year for me that year. So this is what we need to talk about the rest of our time, is the reasonable person standard. This needs to become part of your internal dialogue at all times. And so the burden of proof in civil courts, remember, in criminal court, it is beyond a reasonable doubt. In civil court, it's a preponderance of the evidence, which is a fancy pants way of saying it's more likely than not. That's why OJ won the criminal trial, because beyond a reasonable doubt, no, they painted Johnny Cochran, as a master litigator, painted reasonable doubt all over that sucker. While in the civil court, he didn't have Johnny Cochran, but was it more likely than not that OJ Simpson's actions led to their death? Yes. The evidence it's very much more likely, but is it beyond a reasonable doubt? No. And so the juries did their jobs. So when determining whether something or someone was negligent, a jury is going to be asked to assume this reasonable person standard. So that means that the evidence, viewed in the context of what a reasonable person in any given situation would have done, or when applied to us higher level professions, the term changes to standard of care. So a reasonable person, make sure I'm not getting ahead of myself. So instead of giving examples, we'll just keep going. Reasonable is, like I said, very contextual. A 16-year-old would react to a situation differently than a 70-year-old. Or a 5-year-old running over your foot with their tricycle is not the same as a 20-year-old riding your foot over with a tricycle. That's very intuitive, isn't it? When a 5-year-old runs over your toes, it's kind of what I would expect a 5-year-old would do. Would someone say something? Is there a question? Okay. And so it's very, very reasonable to assume that a 5-year-old doesn't know better, but a 20-year-old does. So hopefully that's making sense in that context. So for you, the standard of care means that the standard at which someone with this amount of training or authority is expected to conform with, like a lawyer understands the importance of filing deadlines in a court and shouldn't expect my client to remind me to do that. A surgeon is expected to not be drunk while operating. I've handled that case actually. A chiropractor understands that he or she are not a dermatologist and should not give medical advice regarding skin cancer treatments. The standard of care is very subjective to what someone in your position should know and do. And so if you're a regular person, if you violate that, that's negligence. But if you violate a standard of care, that's malpractice, which is our level of negligence. And so I have a hypothetical here that we have time to go through. So let's go through it really quick. But I'm going to hit up the chat really quick. So if you get sued for malpractice, which court does it go through? And so yeah, I think I answered that. So yeah, it's civil, but you can be criminally negligent too. So if a surgeon goes in drunk, that's actually also criminal. And so you could actually be charged criminally and sued civilly. And so you will definitely be charged criminally, but you may not get sued civilly. Some people just don't pursue their lawsuits. And someone says they're sorry. That's cool. So let's do this. A hypothetical from one of my favorite Star Wars characters. So on her way home from work, Dr. Aphra, she's a rogue archaeologist, is stuck in traffic when suddenly a semi-truck several meters ahead explodes into a raging fireball. She quickly exits her car and runs towards the Inferno, where she sees it's a truck from the Smithsonian Museum. Acting on pure instinct, she leaps into the flames and rescues several priceless artifacts from certain destruction. By the time Dr. Aphra is finished saving the culturally significant items, she comes around the front of the truck to see the driver laying in the roadway severely burnt but alive. So let's talk about these quick. So one, is Dr. Aphra guilty of a crime? Anyone want to take a stab at that? Or
Well, she's a doctor of archaeology, right?
uh-huh.
Okay, well, I don't think that she has like a medical duty to react. And if she were to react, she might not have the training. So wouldn't she be protected under the Good Samaritan clause to do, I don't know, whatever basic things that she knows?
Yeah. So in general, we talked about this last week. So good answer. You have no duty to put yourself in danger. So if you see a 2-year-old drowning in a pond, you have no legal duty to jump into that pond and save that 2-year-old. You don't have to endanger yourself. So, and in some cases, like if there's a raging inferno, I suggest you don't run into the burning building. You know, I mean, if you're going to be a hero, that's good for you. But in general, you have no duty to endanger yourself. So is she guilty of a crime? I don't see any way how she could be held. Anyone could be. I mean, she could be a first responder off duty whose specific training is to run into infernos and save people. She's not on the clock. She has no duty to act. And so I would argue that no, she's not guilty of a crime. But how about negligence? So let's jump into the civil field. And so was she negligent? Well, let's break down the elements of negligence. So duty, is there a duty she owes to the driver of the truck? So if we're looking at negligence, that means we're talking about the reasonable person standard. So if there's no law that says you have to jump in and help people, well, it doesn't mean there's not a duty. So you're looking at a jury, you're being asked as you sit there, would a reasonable person know that they should jump into the cab of a truck to save someone from an inferno? Now, that's a little bit different, isn't it? Because a jury may think that a reasonable person would do that. And so there's some factors to consider with that may not be applied to everyone else, but a reasonable person, we may have an argument that there's a duty of care there, isn't there? Now, we know the breach would be not doing that duty. And then the damages portion is pretty easy because the driver was injured, was severely burnt. But the causation, was she the cause of those injuries? Well, what are the factors you have to consider? For starters, was he burned before she even got there? So did he already receive those injuries? Maybe she's not the primary cause. Did he rear end someone? Did he cause his own injuries? Was there someone that hit him that caused it? Was the engine designed poorly? Is this a product's liability case? So there's a lot of extra things to consider with causation that isn't just straightforward. So did she cause it? We get that preponderance of the evidence. It's more likely than not. I think Dr. Afra's in the clear with negligence there. And so we kind of understand with that standard of care, which should be if I ask this on a quiz or a test on an essay portion, you should understand that question number 3 is a trick question. She doesn't have a standard of care because she's not acting as Dr. Afra. She's not in her field. She's under a reasonable person standard. So, that's the type of trick a lot of my old professors would pull. I probably won't pull them like that on you in a quiz, but be aware if I'm feeling, particularly salty, I might, put a question in like that. So in your opinion, would the injured truck driver prevail in a lawsuit again for negligence? So just ask yourself this and think about through all these elements. So what is the standard of care Dr. Afra would be held to in a regular life? Well, that of an archaeologist. Would you expect an archaeologist to be more focused on the artifacts or the people? Well, as her lawyer, I would definitely argue strongly that it's her training to focus on the people. And so just in a nutshell, that's kind of how these situations pan out. And you need to analyze every situation based on those elements of negligence. So first look at that duty, whether there's a defined one.
Wait,
like in your
sorry, can I clarify?
Yes,
You
sir.
said based on her job as an archaeologist, her main focus would be to the people. Would it not be to the
No,
artifacts?
other way around. Her focus would be towards the artifacts, not the people.
Yeah. Oh, okay, sorry. Thank you.
And so that is a pretty reasonable assumption that someone in their situation would be more focused on what's going on in the back of the truck than the front of the truck. And so it's all these negligence cases, these malpractice cases are very, very subjective based on what actually happened in that particular case. And so you can't sit there and argue, well, this doctor has been sued 30 other times. That doesn't matter. That's not evidence that can come in here. All we care about is what happened right now. So just because you have a history of running stop signs and running over pedestrians doesn't mean that's relevant to this case. We need to know the duty in this case. You're bringing a lawsuit for all the past and future people, this person might maim. This is your case. What was the duty they owed you at that moment? And it's all that reasonable person. And so you need to play this little game with yourself as you go out throughout the day. At this moment, ask yourself, what standard am I held to? So if I'm in traffic, what's my reasonable person standard here? Well, that of other drivers, right? Dale Earnhardt might be, well, he's dead, right? So Dale Earnhardt Jr., a NASCAR driver, isn't going to be held to a different standard in regular traffic than you, even though he's a professional driver. When you're in traffic, you're held to the standard of the people around you. A truck driver is held to a higher standard of care, a reasonable person standard than a minivan driver, because truck drivers have different training, have different responsibilities, and they have a lot of extra training that minivan drivers don't have. I have someone raising a hand. You have a question?
Yeah, me again. Sorry. I wanted to ask like a more specific question about like one of the biggest risks for chiropractic adjustment would be like maybe a rib fracture, right? But by doing a PAR-Q and maybe having prior charted evidence that they have like osteoporosis or like a higher risk of fracture, charting that plus doing a charted PAR-Q, citing that risk and having that signed as by the patient, does that cover you fully from?
Fully? No.
Would they be able to win a case if all of those things were true though?
Oh yeah. So that's that. You go down that same road. Can they win a case? Yeah. Juries make really, really, really dumb decisions sometimes, and not always based on reality. There are lawsuits, very famous lawsuits out there where the jury's made very, very poor choices, and so you can lose a lawsuit, sure. Here's an unfortunate reality for your profession in particular. There is a cultural stigma in general against chiropractors based on ignorance. Everyone in the world has an opinion on chiropractic until they go in and get adjusted. How many stories do you I bet most of you have this experience. You go, oh my gosh, I don't want to go to the quackopractor. You get hurt, you go in and you leave and you're going, holy cow, it worked. And then you're converted because you've seen the evidence, how it's fixed you. Not everyone in society has had that experience yet. And so there's this unfair stigma based on that ignorance that they haven't actually seen the actual evidence. And so juries will be automatically biased against you, while in other cases, like an MD or a DO doctor or even a dentist, juries tend to bias towards them. And that's just mass psychology, the stupid seminars I go to where they break down these interviews and surveys they do. So juries are automatically going to be biased against a chiropractor just because there's a societal ignorance about it. For now, it's getting better.
But then what is the protection of having signed consent waivers then?
That you have it. Waivers are really important. I have walked through some waivers in the past because you can't really contract out of negligence, if that makes sense. So if you have complete informed consent, you have all the evidence out there that they understood the risks, that you explained them to them. The only real obstacle you're going to have to overcome in that instance is explaining to the jury while you went forward yourself, saying, okay, I knew she had osteoporosis. However, here's my medical justification as to why I felt, as a professional, why I felt this was important. And then you would have to try to explain that in your best terms to a jury of not chiropractors. It's an uphill battle, but a waiver is a good protection to have. And you definitely have to have waivers, but you're going to have to explain to regular folks in your opinion why you decided to move forward with this. And sometimes it's as simple as, listen, I've handled a dozen other cases exactly like this. It's never happened before. I can bring up redacted chart notes as demonstration. I have an expert witness we paid a buttload of money to come and testify to this. By the way, that should be your career goal, to be an expert witness. Develop a callus where people can't affect you and come make money, because holy moly, expert witnesses make money. And I use chiropractors all the time as witnesses. So you need to have that waiver and all the documentation you possibly can to justify the action and that she or he understood it. But in the end, there's no complete 100% protection from anything. It's like a seatbelt. You definitely should wear your seatbelt, but sometimes you still, get ejected. Sometimes people still die wearing their seatbelts. Is the part going to ensure your malpractice insurance carrier sticks with you? Yeah. The most important thing to make your insurance stick with you is to pay them. They really like that. Abiding by standards of care, because if you do something so egregious, they may just drop you. They're still going to be on the hook because they covered you, but you don't want to step outside the lines of what's required of you, and that's taking your dang chart notes and making sure they're documented that you took the PAR-Q steps, and make sure those were well established. So consents, all sorts of stuff. That's all really important to have. So we're out of time. I'm going to hang around for a minute if you have questions. The quiz should post automatically this time. Thanks for letting me know it didn't last time. But let me know if you have questions. I'll hang out. And thanks for another good week.
Thank you.